Dr. Alford and Attorney Thompson. So according to the sign-in sheets, no one else is here to present oral testimony, and so we'll listen to this testimony and then we'll proceed with Stan Yasuhiro. All right. Mr. Lubofsky, is it okay if I ask you to keep your testimony to 5 minutes? And we will allow everyone to talk, and then we also want to put on the table all the proposals that have been made, if that's okay. Please proceed.
Good afternoon, Senators. Thank you for allowing me to give testimony again. My name is David Lubofsky. As you know, I'm the father of Asher Dean Lubofsky. And I'm here, as I said in the last meetings, to give a voice to my son and the hundreds of people on Guam that have died or have been injured due to negligent medical care that continues to go unaccounted for. I have some recommendations to make regarding new laws and regarding arbitration, but I'll do that later on. I want to make some points first. In the last meeting, I want to touch upon this, please. Dr. Berg, the chairperson of the Guam Medical Board of Examiners, implied public policy should not be changed based on the death of one child. That statement alone should worry all of us, as it comes from either being uninformed or wanting to hide the truth of what arbitration has done to the people of Guam. Sure, I have been verbal, and Asher has given a face to the apathetic Arbitration Act that kills and hides. But I would venture to say, based on national statistics as presented in the last meeting, that there are thousands of people over the last 30 years that can attest to loss or injury of family members due to medical negligence, not to mention the dumbing down of medical care on Guam. For me, it's a no-brainer, and for the folks that I speak to outside, it seems they all understand that. The most important thing we can do for health care on Guam is to repeal the Arbitration Act and allow people to go directly to court and figure things out. That's my opinion, and simply put, what I think should happen. Let the courts figure it out, allow due process, our constitutional right. With that said, it's probably unlikely that will happen, as negligence has been rewarded over the years, and it's hard to change mindsets. So I concede. Alternatives are important to impact change, and that will benefit the island and protect us from negligent doctors. In any case, with any new law, there should never be such secrecy as we now see in the process. We already have a law in the book called the Patient Protection Through Information Act. This is all about a physician's profile being public information so we can know who these doctors are, complaints against them, and make informed decisions as consumers of health care. This is a law that has been ignored for 8 years, especially by the Guam Board of Medical Examiners, who is charged to implement the law. It should have been on their website for years. Guam needs an open malpractice system that is not hidden behind closed doors, that protects the citizens with the goal of improving health care. Open information leads to decisions by all of us as to where we want to take our family members. If doctors want to hide what they have done and threaten to leave using arbitration as an excuse, let them go. We look for quality, not quantity. With that said, at the last meeting, I did not hear one doctor say they would leave Guam. One doctor said, if insurance got too expensive, he may consider leaving. Well, after all these years, doctors have paid one of the lowest malpractice premiums in the country. So being realistic, there may be increases. Why else would doctors leave Guam? Doctors on Guam are some of the highest paid in the country. Yes, doctors on Guam are some of the highest paid in the country. This little known fact brings doctors here, makes recruiting easier in contrast to what some have said, and keeps doctors here once they arrive. I have references to that in my paper. This is important info, and I'm telling you, doctors should be paid well, very well. But when they say they may leave or malpractice insurance may get too high on Guam, their counterparts in the USA are earning less on average and are paying much more for malpractice insurance. So, if anyone wants to leave, it will not be due to arbitration repeal or salary or income. It may be due to a history of negligence that will become a public record when arbitration is repealed. Actually, this info gives credence to the fact that it's really easier to recruit for Guam than our doctor friends want to let on. According to one doctor, a friend of mine, he said it's easy to get doctors to come to Guam these days with the internet, information available, high salaries, and ease of getting licensed under Dr. Berg and the Board of Medical Examiners. Anyway, we're here today to figure out where to go from here and how to resolve the deadly crisis created by the Arbitration Act. And what I see is the related demise of medical care on the island. I have read the laws over in most states, especially Massachusetts and Hawaii. And I have spoken to doctors here on Guam and so forth. Let me first state emphatically, though, it's still my opinion, as stated earlier, that the Arbitration Act should be outright repealed and all cases go directly to court. I did come up with an alternative, if I can indulge you. First of all, the alternative would be is to allow 3 years to file a malpractice case, as in most places, not the 1 year that we have now. Once the case is filed, a 6-month cooling off period should begin, in which two things should happen. One, the claimant and defendant would submit their claims to an off-island organization like Mountain Pacific Quality Health, which I'm told has served Guam before. They would be tasked to look at the issues and make recommendations to help improve overall care on Guam and to help make our community healthier and to ultimately lower health care costs. They could compile info and look at trends on Guam, such as problems at a certain neonatal ward or issues that repeat themselves over and over again at certain clinics or at the hospital, and make recommendations for improvement. They are off-island, so that it will not be the local inherent bias that has been discussed and mentioned as an example by Attorney Mitch Thompson during our first meeting. This organization or a similar organization can do a peer review of the malpractice claim or any complaints that the Board of Examiners receives regarding doctors. The second thing to happen in the 6-month cooling off period would be mediation. Mediation should happen during the 6-month period, but it's not mandatory. The information from the peer review, which I just mentioned, can be used during the mediation for discussion and try to resolve cases before they go to the next step. All costs are the responsibility of either the doctors, clinics, or it can be covered by a fund that's set up. Claimants or defendants can waive mediation. At the end of the 6 months, if the case is not resolved through attempted mediation, then parties should be allowed to proceed to court via a conciliation process. This is very similar to what Hawaii does. Medical Inquiry and Conciliation Panel, MICP, similar in Hawaii. Before a medical malpractice lawsuit can be filed in court, it requires that the proposed plaintiff submit an inquiry to a Medical Inquiry and Conciliation Panel, consisting of one attorney and one properly licensed physician. Again, in my opinion, which should not be from Guam, should be an off-island person. The inquiry, as similar in Hawaii, must include several factors. The facts on the lawsuit will be based, the names of health care providers, and so forth. After receiving the inquiry, giving notice to all named care providers, and so forth. The panel sets a date to consider all evidence, review the medical records, and hear from witnesses. The panel then issues a review of information decision. This info cannot be used in court, but this decision should not prevent court. The goal of the MICP process is to provide non-adverse review of claims by patients and their families to facilitate the conveyance of information without assignment or blame. When the parties are not able to resolve their dispute, the MICP process attempts to narrow and define the claims and to address questions of causation, liability, and damages in order to help the parties better understand the nature of the claims and to help and encourage them to reach a voluntary solution. Statements made during the course of the MICP process and any recommendations made as a result of that process are not admissible in the later court proceedings. The proceedings is not closed to others unless both parties agree. The information in step 1 that I mentioned from the peer review can be included in the MICP process. If the parties cannot come to an agreement, a court case is allowed. I also touched upon financial caps, economic caps, and so forth. Do you want me to?
Just read the topics. We're
Okay.
already at, way beyond the 5 minutes.
Okay, I'm
Just
sorry.
read the topics and we will,
Okay. Anyways, financial caps.
All right.
There should be no economic caps under any circumstances. Taxpayers are not responsible for doctors' mistakes.
no caps.
No caps.
All right.
Economic caps.
Yes, okay.
Non-economic caps should be set at a certain amount.
Yes.
I put down, and that's here in my
Okay.
paperwork.
Yeah, we just want a list right now.
Okay. Legal fees, I covered that. Collateral source rule, I covered that. Punitive remedies, and so forth, and I covered that as well. And again, I reiterated the Patient Protection Through Information Act, which is already Guam law, should be
Yes.
put on the website and should be enforced immediately. And pretty much that's all with my time limit. And
Appreciate that. If we could get a copy, I'd appreciate that, and we will make sure we
Thank you, Senator.
provide that to all the senators. And as to the information on the website, yeah, I've been following up with that, and that should be up to par very soon. So I know, and you were right. It should have been up there. Some of this information should be there. The new law that increases what's going to be put on the